Testimony training video for preparing an expert witness for court. First stated the importance of coming to trial being as prepared as possible. Being prepared improves the credibility of an expert witness and can have profound effects on the success or the demise of a case. The following training video will help provide ways and concepts that can enhance an expert's preparedness for trial and mitigate pitfalls that may be encountered throughout a trial proceeding. There are three phases of testimony in a courtroom proceeding. The first phase includes information how you, as the expert, are qualified to speak on certain topics within the proceedings. This is usually based on education, training, and any experiences that you, as the expert witness, has on that specific topic area. The second phase is the direct examination. This is the questioning of a witness by the attorney who actually called the witness to testify. The goal of direct examination is to provide supporting facts that assist the attorney to prove an element of their case. It also establishes the credibility of the expert witness by addressing how the work was completed and your opinions and how you reached your conclusions in a clear and persuasive manner. It is usually considered the foundational portion of the trial. The final phase, or the third phase, is the cross-examination. The cross-examination is a term that is used to describe the re-questioning of the same expert witness and is usually done by opposing counsel. Questions are asked usually to try to discredit a particular witness by focusing on inconsistency of that witness's testimony. Redirect examination allows attorneys to ask clarifying questions for statements that were made during cross-examination. This is done to solidify the witness's testimony and to present testimony that focuses on any line of questioning that may cause concern for the original attorney. It is always important during these phases to remain calm by practicing patience and to remain professional and to present information in a manner that keeps the jury engaged with your testimony. Communication should always begin between an attorney and an expert, as it can aid in the successful testimony given by the expert. But when communication between an attorney and an expert are non-existent, there are steps that an expert can take towards providing an effective testimony. To provide an effective testimony, it's important to determine or decide the who, what, when, how, and whys of how you will present your report. This will include your credentials, any training and experience, what exactly was your assignment for evaluating evidence or any situation regarding the trial, how you performed your evaluation, your observations, and how you developed your conclusions. Next, you will decide how you will present your testimony with the use of examples for complex concepts to the court. The use of visual aids will be inadmissible if you are not directly communicating with an attorney. You should also be very meticulous in your understanding of your portion of the case. Practice discussing difficult concepts to those who are less familiar with the information for their understanding. Being able to be clear and concise when giving your testimony helps enhance understanding and improves credibility and your impact to the jury. 4, you should familiar yourself with your trial setting. Make sure you know where the witness stand is, where the jury will sit, where will the visual aids be, where are the electrical outlets, how does the computer system work, does your flash drive work in the computer, those kinds of things. You should also be reviewing all the documentation relating to the case to look for any strengths and weaknesses. This will allow you to mitigate for questions that you do not have control over, thus making you seem more prepared to answer and to also, again, increase your credibility as a witness. Objections are made at a trial when an attorney or a witness has violated proper legal behavior, and it is usually made by the opposing attorney. Most often than not, the opposing attorney will use the phrase objection. Not always necessarily the case, though. It is important that an expert who is testifying in court stops talking when an attorney is about to start talking and leave the conduct of the courtroom to the judge. There are many reasons why an attorney can object to a line of questioning, such as relevance, where the question asked does not relate to the case or the matter at hand, leading or compound questions, which will be discussed later in this presentation, hearsay. Hearsay is secondhand information, might be, I heard from so and so that the color of the sweatshirt was black. Speculation is another reason an objection can occur. These are questions that ask or require an opinion that is based on a guess and has no supporting evidence. Another might be asked and answered, which means that a question has already been asked and the question has already been answered, similar to the one that the attorney is already asking. Argumentative. This usually promotes an argument with the witness and does not gain any information based on facts. Another might be lack of foundation. Questions which are asked that have no context given or any background information. Objections are very useful and are used to ensure that court proceedings follow the rules of evidence and promote a fair trial for the accused. Being able to identify what types of questions will be asked during a trial and effectively handle each type is important to answer in a manner that promotes clarity and authenticity on behalf of an expert witness. There are two basic lines of questioning that can occur by attorneys, either compound questioning or leading questions, both of them which can lead to an objection that was previously discussed on the slide before this one. So compound questions are those that try to incorporate several questions into a single question and are used as a mean to confuse the witness. They can be usually identified by the words and or, and cannot be answered with a typical yes or no response. When compound questions are asked, it is definitely okay to clarify which part of the question the attorney would like a response to first. For example, on the slide you see the very first question under compound questions is, did you review the evidence from the crime scene and write the report? So it's okay to ask the question, which would you like me to respond to first, and then answer appropriately. Leading questions are those that try to lead the witness to a specific response. These questions can be identified because they can end up with such phrases as, isn't it, or didn't you, whatever the question is. They tend to imply their own answers. To appropriately answer either line of questioning, it's really important to stay professional, seek clarification, maintain integrity, and stay within your area of expertise. As an expert witness, there are many opportunities to become a better witness by presenting yourself as credible and a confident witness. To enhance a direct examination, there are 5 points to consider. It is important that an expert can verbalize testimony, which should align with any kind of reports, charts, exhibits, diagrams. This should all be done in an effortless, linear manner in order to smoothly project the information you're trying to convey to the jury. You should too convey facts, ideas, and concepts in a way that is easily understood by all those involved in the court proceedings by removing any kind of scientific or technical language. Be able to teach your field in a way that is energetic and allows participants to be invested and engaged. The third point to make is provide supporting opinions that align with the evidence. If an expert states their opinion with no proof to support their opinions, it can be a display of incompetence and can lead to biasness, which ultimately affects the credibility of to the jury. Make sure that when you are presenting information that you, again, number 4, Be confident, be professional, and composed. Make sure you're maintaining eye contact, speak clearly, and maintain a strong yet relaxed body posture, which invokes a feeling that you are well versed and prepared for providing your expertise. It is important to note not to appear to be overzealous or overconfident. This can be off-putting by the jury. The last point to make is showing a comfort level with the materials and the courtroom experience allows others to review your testimony as reliable and credible. By displaying a comfort level, you can highlight your experience and promote trust and enhance professionalism that can have a positive impact of a jury's perception of you, the expert. We talked about cross-examination just a few seconds ago, and cross-examination is a time for the opposing legal team to ask their own questioning of a witness. The main goals of cross-examination is to discredit the witness by asserting that there were errors in a witness's testimony. Usually attorneys will try attacking the integrity and motives of the witness and challenge the expert's process of deduction of their developed conclusion. The attorney will also try to navigate the narrative of the case by using leading questions, which can only elicit a yes or no response. Asking leading questions manipulate the perception of the witness by the jury, which again, as stated before, can lead to bias and has the potential for objections by the opposing counsel. To reduce the vulnerability in cross-examination, we must remember that it is the job of the opposing counsel to discredit your testimony. They do this by revealing any weaknesses in your testimony and exposing them. To provide a solid testimony helps reduce being placed in precarious positions by the attorney. It is important to make sure that you, prior to the trial, review any documents, look at your prior testimony or your deposition, any kind of work related to the case, the facts, the evidence, any legal standards that you should be following while you're at trial. It's always very important to, again, remain calm. Attorneys can pick up on the insecurities of certain body language, especially if you're lacking eye contact, and they can use this to their advantage. Make sure to remember to breathe and pause before answering any of the questions. Recoup your thoughts, make sure that you're clear with what your answer is going to be. Remain objective by sticking to the scientific facts of the evaluation of the evidence and not based on your personal opinions. When responding to a line of questioning, remove out all the technical or scientific terminology that can make it easier for juries to understand the complex concepts you're trying to portray. Always stick to what you know. It's always okay to admit when you don't know what you don't know or ask clarifying questions. One of the biggest things I think that can help reduce vulnerability in a cross-examination is to practice. Practice mock trials, rehearse answering questions similar to those that might be asked during trial. Go over your testimony, explain your concept to those who don't know anything about your line of work and see if they can easily understand it in very few words or very few sentences. In conclusion, this was a very, very brief video that covered only a fraction of the topics that could be covered to improve your credibility as a expert witness. The main point to consider, and cannot be understated, is the amount of preparedness that should go into being prepared for trial. Being prepared can be the difference between a successful testimony or one that is less than successful. Knowing the types of questions that could be asked, communicating with your attorneys, reviewing any documentation of your testimony and other documents related to the case, the ability to teach hard concepts to the layperson for easy understanding of difficult concepts, and retaining a calm and professional manner all can assist in promoting the success of your expert testimony. Practice, visualize, and execute well.